Okay, before we get started, this account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many people, I suspect, who are worried about their immigration situation but are not sure if they should speak with an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if the hypothetical that I analyze here sounds nearly identical to your situation, you still need to speak to an immigration attorney. These smallest factual differences can change everything. That said, this is not legal advice. I'm merely hoping to educate some people on how the immigration laws work, because I know that a lot of anxiety exists out in certain immigrant communities. Also, immigration laws and procedures will likely change significantly over the next few months, so what might be accurate and current at the time of recording could be outdated in the weeks to come or even tomorrow. This man entered the United States in 2005 and was not caught and never left. In 2018, he was placed in removal proceedings in immigration court. He has no criminal record. He hired an attorney and the attorney pursued a U visa, which is still pending. At some point, the immigration court was unwilling to continue his immigration case to wait for the U visa to be approved, and the man was ordered deported. He has been checking in with detention and removals every 6 months to see when he will be deported. The family is very worried that at his next appointment, he will be taken into custody and sent back to Mexico. This man and his wife have 3 children. The youngest is 13 years old and has autism, oppositional defiant disorder, and ADHD. The child also has an IEP from the school district. This is likely a matter of Lozada case, okay? So in the situation that your attorney makes serious errors in your case and it results in a deportation order, there is a way to get that reopened so that you can continue to fight your case or have a new attorney try to represent you. In this situation, the reason I think that the attorney potentially made an egregious error is because they applied for the U visa. I'm assuming that the U visa was a valid application, and just to remind you, a U visa is when you are the victim of a certain crime. It has to be of a certain level, okay? But you're the victim of a certain crime, you cooperate with law enforcement, and the law enforcement is willing to certify that you were cooperative during that process. There is a path to getting a green card through that. However, U visas, they only give out 10,000 of them per year. So that line can be many years long. It can be 4, 5, 7, 8 years long to get to the front of that line. So in this case, the judge was saying, apparently, that they weren't willing to put this case on hold for 7 years, and so ultimately he was ordered deported. Now, where I think the error came in is that these people seem like they are perfect candidates for cancellation of removal. He's been in the United States for over 10 years, 3 U.S. citizen children, and one of them has autism, oppositional defiant disorder, and ADHD, and we already have an IEP with the school showing that he's getting accommodation. So to not pursue that and to not bring that up in court as a pathway that the attorney was going to pursue to try and get a green card, that seems like a very big error and a potential ground to get the case reopened based on attorney error. So in a matter of Lozada case, you are trying to reopen the deportation order, and what you must do as an initial step is file a state bar complaint. Okay, so you file a state bar complaint with the state bar. In this case, for me, it would be California. Once you've filed that, then you can go to the court and show, look, we filed this state bar complaint. Here are the facts, include evidence of the autism and the fact that this individual's been in the US for over 10 years. Include all of that as part of the argument that the judge needs to reopen this case because a horrible mistake was made and this individual deserves proper representation moving forward. Now, I don't know when the next check-in is with detention and removal, but normally they space those out about 6 months. So depending on when the last one is, it could be coming up. So For something like this, you want to get that process rolling really quickly. You need to file that state bar complaint, then you need to file that motion to reopen. At your next detention and removal interview, you can go in there and show, look, we're in the process of doing this. Maybe we don't have a decision on reopening it yet, but we've filed everything that we could. Very time sensitive for a situation like this. If you have questions, if this sounds like something that might apply to you, you can call our office and we can see if it's something that we would be able to help with. Good luck, everyone. Take care.